As I said, if some of you may have heard, tonight's going to be a whiteboard presentation because as I was thinking about putting this together, there's a lot of drawing that's going to go on as far as showing how pieces fit, and I didn't feel that a PowerPoint is really conducive to this type of presentation, because really what this is about is strategies. If you live in California, how can we set you up with a structure that are going to address some of the issues that concern you? And we're going to get into that. And so that's going to require some careful planning. And so tonight what I'm going to do is I'm going to walk you through some structures for those of you that maybe already have created something and show you how to tweak it and fix it, make it a little better. And then I'm going to show those of you that haven't yet created something, but you know you need to do something, because it's just not a matter of if, it's a matter of when something's going to happen. And I often joke about this with people. I've never yet had one of my clients come up to me after being involved in a lawsuit and say, Clint, I really regret putting together all that asset protection stuff that saves me. It's always the opposite. They'll come to you after somebody's been involved in a lawsuit, and they'll say, I wish I would have had that in place prior to getting sued. So I'm going to show you certain structures that you can do. And so when you're first going about creating the structures, we look at things, or we strategize in a very specific way to build multiple levels of protection into someone's plan. Because I think overall then it creates, or it hits many of the high points or many of the issues that attorneys look at when they're coming after you. And if you have a really solid plan, it discourages anyone from trying to take what you've built up. And believe me, they're out there. Attorneys are very aggressive. Thankfully, though, if you structure yourself properly, they many times, as I stated, they won't come after you because they're also lazy. And I think the best example I can give of this is a conference call that I was on last Friday with one of my clients. He was involved in a lawsuit in California, and there was a settlement agreement reached where all of the parties that were named were released besides his corporation. And part of the settlement stated that his corporation would have to pay X millions of dollars in settlement. Well, what the attorney failed to do in reaching the settlement negotiation is first determine whether or not the corporation had any assets, perform any type of debtor's exam on that corporation before they accepted that corporation as a responsible party for their claim. Well, it turns out they settled this lawsuit out with my client's corporation that has next to no assets. And so recently they went into a hearing to enforce the judgment because we've been telling them we can't pay because we have no money. And of course their complaint is, well, that's not fair. You owe us this amount of money. We agreed to it in settlement. Well, that's fine. Yeah, I agreed to have it, but my company just hasn't made any money, so I can't pay you. It's your fault for being lazy and not following proper procedures. And many times you just find that with attorneys, they're just so greedy, they want to get paid right away. And if you put up really good defenses, they will not come after. If they do, they are thwarted in their collection efforts. So that's what I like to create for my clients, and I've got a number of success stories where people have been involved in lawsuits, and by utilizing the strategies that we teach, they've kept down and held on to their assets, because the vast majority of these claims that my clients have dealt with are all frivolous. They're shakedown lawsuits, and unfortunately we have a legal system that encourages them and allows these people to go forward. And who knows what happens with the election. I only see this getting worse as we go into next year. So let's talk about business basics. I just want to nail this right to begin with. If you're doing business in California, okay, you must register. So let me just say this. You must register in California if you're conducting business. That is a requirement under California law. So what does it mean to say that you're conducting business in California? Well, one of the tests they look at, number one, is they want to know is it regular and continuous? Okay. Now, what do we mean by that? So if it's a regular and continuous activity, what we look at is we say, is this business enterprise occurring in California on a fairly consistent basis, that is every month or every week or even every day. So if there's stuff going on in California in which income is being generated, then the business is considered to be regular and continuous. The other issue we look at is, do you have employees in California, and are you paying salaries to people who, of course, live there as well? So those are other factors we look at. Now, the reason why I want to start the presentation with this particular information is because a lot of people are unsure what constitutes doing business for their particular type of activity. Now, I work with a lot of real estate investors, and this comes up a lot. I mean, we understand that if I opened up a donut shop on Sunset Boulevard, I'm doing business in California. So if I create a business entity to minimize my liability exposure, it's going to have to register in California. But when you start looking at other types of activities, sometimes the lines become blurred. People hear things on the internet, they talk to someone in a sales organization that's maybe an entity mill that's set up in Nevada or Wyoming, and they're told they can run certain activities and not have to register in California. Okay, planning around California is not about acting in that manner. Okay, that is, we're not going to circumvent the law, because if you do that, you can run into problems, which I'll explain in a second. So what we look at here, let's say you're in real estate. If you're flipping real estate, okay, that would be considered a regular and continuous activity. If you're there buying and selling property inside of California, you're conducting business there. If you're wholesaling real estate, then and it's to people who live in California and you happen to live in California, then you're conducting business there. So any activities or entities that you create, they need to be registered in California. Property management would be another one. So if you're engaging in this activity, if you're managing real estate, and I'm not referring to other people's property, just your own. And the reason I say this is because many people will create an entity. Maybe they set up a corporation over here, and it's set up to manage their rental real estate like this. Well, this corporation needs to be registered in California because you're managing that property on a daily basis. So it's a regular and continuous activity. The common mistake that we have with a lot of people is that they fall victim to these out-of-state entity mills, and they tell them, hey, you can run your active business out of Wyoming. So you run your active California business out of Wyoming or Nevada, and that is just plain out wrong. And the reason why is because if you set up a Nevada entity, so we have, here's my Nevada corporation right here. If I set this up and I want to conduct business over here inside of California, and for instance, I'm going to flip property. Well, I can do that. I could have this corporation buy this house, own it, rehab it, and then flip it. But the problem is that if anything goes wrong during that process, and I have to sue, here's this contractor over here, he didn't do something that he was supposed to do, and now I need to sue him. Well, I could not bring a claim against him in California. I could try, but I would be bounced out of court because the court would say your corporation is a Nevada corporation conducting business over here in California. It didn't register. So in order for you to be compliant, you need to take this Nevada business and then register it in California to conduct business. The problem with this strategy is that many people here started in Nevada because they want to take advantage of anonymity. Okay, so they want to benefit from not having any of their information listed. They want to avoid franchise taxes on any of the income they generate inside of California. They like the asset protection benefits that Nevada or Wyoming provide. So these are three great reasons to be incorporated there or set up an entity there. And I'm going to show you how you can do it legally in a few minutes. But these are the reasons why people start here. But when they run their active business over here in California, and once they register that company there, they lose the anonymity, they lose the ability to minimize franchise taxes, and they lose the asset protection benefits that Nevada and Wyoming offer, because now you fall under California law. The only thing you do not lose in adopting this strategy is the privilege to pay the company who set up your Nevada entity X amount of dollars per year to maintain it, plus the dollars to the Nevada Secretary of State to keep that entity alive. Let's assume that's a corp, that's $735. And at the same time, you're still paying California $800 franchise fee, plus, you know, your other fees that go along with it. So you've just doubled up your fees. So this is not how we want to run our business, okay? We want to set up a structure where we bifurcate out the activity and we say, all right, if it's an active activity, it's going to have to be set up in California. Now, we can accomplish some of these things right here, anonymity, minimizing franchise taxes, and asset protection, if it's structured properly. But just going about setting up an entity and trying to conduct business, that does not work. So what constitutes not conducting business in California? What could you do where it would not be considered conducting any type of business? Well, one thing you can look at is owning property, owning real estate without nothing more. Okay, just owning real estate. So if all you do is own real estate and there's nothing else going on there, then that's not conducting business in California. You can have an entity set up to own property. So not property management, but just owning the property. That's fine. If you're a trader, okay, so you have a trading account and you're actively trading, that's not considered to be conducting business in California. So that's fine as well. These are two common activities a lot of the individuals with whom we work with typically run through their businesses. Okay, private lending. Now, I did say private lending could be an activity, but it can also not be considered an active activity in California. This would depend on where you're making your loans. If I'm in California and I am advertising just to people in California, only working with California residents, I live in California, well then you're doing business there. But I have a lot of clients that live in California and a lot of their loans take place outside of California, you know, Texas, Arizona, North Carolina, Indiana, Florida. So they're loaning all over. California does not constitute a very large portion of their overall portfolio. So in that case, you could argue that that's not conducting business in California because the activity is taking place outside of the state. So these are common activities that do not constitute doing business. So that gives us more flexibility in our planning. Now, this is important, okay, when it comes to planning for California, because we have basically three problems, okay? And these three problems, number one, that we typically have is the franchise tax, all right? If you've ever set up a business in California, you're aware of what I'm talking about. It is $800 minimum per entity that you create. So let's assume that you have 6 rental properties, 6 LLCs that you want to create in California. And this is why a lot of people do not set up strong asset protection structures, because they can't afford it, or they don't want to make the investment that is necessary to protect their property. So if you look at 6 times 800, that would equal $4,800 a year to protect your 6 properties. Now, when that number is floated by someone, they say, well, that's too much. Well, it depends. I mean, if you think about it, if those 6 properties had a fair market value of $6 million, and it's only costing you $4,800 to protect them, I think that's pretty cheap insurance to have 6 LLCs set up for the type of asset protection you could gain. So you have to consider this, you know, consider the overall numbers and what's at stake. But this is a concern for many people. The second problem with California is it does not have charging order protections. Now, what are charging order protections? Well, those are the protections that prevent a creditor from taking your business from you, your LLC. For example, if you had a limited liability company right here and you had a house inside of it. Now, you're the owner, of course, down here. And let's put your wife in there. Together, you guys own this LLC. If a creditor sues the limited liability company, that is, something happens with the property itself, maybe it catches on fire, you name it, then the lawsuit that this creditor right here is going to bring is going to be against the owner of the property, and that owner is the limited liability company. This is not what we're referring to when we talk about charging order protections. This is a typical scenario where the entity itself is holding a dangerous asset, and the dangerous asset is the cause of the harm. So that's one form of liability protection, meaning that if the asset causes the harm, then these two owners are protected from the liability associated with that LLC. So what they could do is just dissolve out their LLC and the harm goes away. Now, the second form of protection we look for when we create limited liability companies is what is referred to as outside protection. So in this example, our LLC is just fine. It hasn't done anything wrong. It's perfect. Let's assume a different scenario. Husband jumps in his car and he pulls out of a driveway, or yeah, he comes out of a driveway and he's going to turn right. So if you're turning right, where do you often look? Well, you look left, right? So he's going to turn right, he looks left, and he doesn't see this guy comes running, that's running by, he's a jogger, and he flattens him, okay, as he's pulling out. Now, who is this person going to sue? He's going to sue the driver of the car, so he's going to bring a lawsuit against the husband. And he's going to get a judgment against him for the injuries he sustained as a result of the husband running him over with his big SUV. Now, a judgment's entered against him for $1 million. So now the question becomes, when you ask the husband, what do you own? He says, well, I own an interest in this limited liability company right here. Well, in California, the creditor can take this interest from you. So they become the owner of your LLC through what is referred to as a foreclosure action. It's written into California statute that a creditor of a member, so you're a member, can take your LLC interest. Okay, now if you're in a state that offers what we refer to as strong charging order protections, then it's a much different narrative because the creditor is not allowed to take your interest. So you do not lose your LLC in this lawsuit. The only thing the creditor can do is what we call charge your interest with that $1 million, meaning that if you, who manage this LLC, decide to take out $100,000 cash as a distribution, then as long as you're pulling out money, it's going to go to your creditor. So next year you take out $50K as a distribution, it goes to your creditor. $20K the next year, it's going to go to your creditor until that $1 million paid off. Well, I'm sure you can grasp that if you're in a position where you control the distributions to yourself, and you know that if you tried to take out a distribution to yourself, it's going to go to this creditor down here, obviously, we're not taking distributions. So this puts a lot of power back in your hands as the debtor, because the creditor realizes that against an LLC that's not filed in California, their likelihood of recovery is nil. And so it's either settle or just not even proceed against the individual or try to collect because they're not going to get anything at the end of the day. So we want a state, we want to create entities that shelter our assets that offer these charging order protections. California does not. It offers inside protection, which many states, all states offer that, but it doesn't offer the outside protection, the charging order protections. And then the third problem I look at with California is that there's just too many damn attorneys in that state. All right? It's a fact. There are more attorneys in California than any other industrialized country in this world. I mean, so you got all these attorneys scrambling to make money, to live, to support their lifestyle so they can drive their BMW 7 Series, send their kids to private school, and they're doing it off the back of individuals who are out there trying to better their lives, save for their retirement. So you have these culmination of factors that when you look at California, you're thinking, man, it's very difficult to do business here because of the way the laws are set up. So those are three problems that you have. And then actually there's one other problem here is income taxes. All right? Income taxes is another problem that you have in California. I just want to mention this. That's just a cost of living there. I get these questions a lot from people. I've been told if I set up an LLC in another state that I don't have to pay California taxes on that income. That is false. Okay? If you're a resident of California, you're taxed on your worldwide income. Any money you earn is taxable in California, subject to California state taxes. And so you always have to decide, do you want to live there and pay that tax? because that is a cost of having the sunshine and the water right next to you. So you can't use anything, any type of entity structures to ever eliminate California income taxes. If you're taking the money and you live in California, you're going to pay taxes there. So those are some ground rules that I wanted to lay out so we're all on the same page. So now I'm going to show you how do we go about structuring people who own assets in California for asset protection. So let's just talk about owning real estate. All right, if you own real estate in California, what should you do? Well, option number one is this. Obviously, you should create a LLC to own your property. Okay? So let's say we're going to start with 3 LLCs because they own 3 properties. Now, I would want to have 3 limited liability companies created to protect these assets from me. Now, many times people are in this scenario. And that is, they've already set up the structure. They're working with a local attorney, they're working with a CPA. And so I want you to think on this for a minute. You've already created your LLCs. Typically, if you're going to create an LLC, you probably set it up in California because that's what your local provider is going to tell you to do. So maybe you're that person right now. You're listening on this webinar and you've already created your California LLCs. Hopefully you don't have a bunch of properties jammed into them like this, because of the reason I just described, that if something happens with one of them, you can lose everything. So you've done it where you've created 1 LLC per property. But nevertheless, you've created this structure. Now, is this a bad thing? I get this question all the time. Clint, I've created 3 LLCs. I'm protecting each of my properties. Is there a problem with this? Well, yes and no. I mean, the benefit of this structure is that you have what is called inside protection. All right. And what I mean by that, I've already described it, is that if something happens on the inside of this structure and you're down here owning the LLC, then it stays contained in this box. It's not going to get outside of the box. It just stays right in there so that you don't have any personal liability exposure to that. But the drawback to having this structure in place is that, number one, you have the franchise fee. So you have to pay the franchise fee of $800. You have no outside protection. That's the charging order stuff again. So there's no outside protection, and there's no anonymity with this structure. That is, I know you're associated with these LLCs because your information is now made public. It's through the Secretary of State that I can find you. One of the things about asset protection that I focus on a lot, and when it comes to the upcoming asset protection event we're going to be teaching in Vegas, I'm going to be going deep into how to make yourself appear worthless, because I think that's a key component of any asset protection strategy is privacy. Make it appear as if you don't own it, because if they don't think that you have something, then they're not going to come after you. The example I gave you earlier here with the car and the husband hitting somebody looking left and then not looking right, well, that is an example. That is a story that occurred actually to my partner, Greg. He was the runner, and he was hit by this, I don't know, I forget the type of car. He said he was hit by this Chrysler car, beat up old car where it had 7 different colors on the car, different paint jobs. It clipped him, knocked him on the ground when they were pulling out. He got up and he saw this beat up old car, and this woman gets out that was a driver. Hair's a mess. She's in a muumuu, he said, and slippers that didn't even match. And he looked inside of her car, and there's I think Palmaro cigarette cartons everywhere, fast food wrappers, and soda cans, empty soda cans. He said it was just a pigsty. Now, she could be worth $20 million, but by the way she presents herself to my partner, he chose to walk away from that potential claim he had against her. He got hit pretty hard. He's like, why sue somebody? They have no assets. Now, he could have gone and possibly done an asset search, but when he did his initial assessment of that individual, there was nothing there. So it would be a wasted exercise. Well, I'm not saying you have to drive around in a beat-up old car that's been pieced together within 7 different paint jobs and wear a muumuu and different colored slippers to achieve this. But you can set it up through business entities the right way where you have anonymity. No one knows that it's you that owns it. And so that is always going to be your first shield to a lawsuit. And that's something when you come to the asset protection event, we're going to go into real deep. So in this structure right here, you do not have any anonymity. So there's some drawbacks here. Now, we can make this type of structure better. If you've already created LLCs and you live in California, then what we want to do is take those limited liability companies that you have right here, that owns our property, and we're going to replace you with a holding LLC. You can do this. You can create a holding LLC in Wyoming, or you could use Nevada. I prefer Wyoming because it's less expensive now and the laws are pretty much on par with each other. So now instead of you owning the LLCs that are in California, your Wyoming LLC owns it, and then you own the Wyoming Limited Liability Company. Now the advantage to this type of structure right here, the benefits is that you have inside protection, and now you also have the outside protection as well. And the reason you get the outside protection is because you no longer own your Wyoming or these California LLCs. They're owned by a Wyoming LLC. So if somebody came after you in that example again and they sued you, then you're brought into court and they say, what do you own? The only thing you own is a Wyoming LLC. But your Wyoming LLC, of course, owns 3 California LLCs. So they can only go after what you hold. And the only thing you hold is an interest in a Wyoming LLC. So this type of protection, what we call this is a holding entity called a holding LLC right here. So that holding LLC provides you a level of protection. Now, you'll see that we still have some drawbacks here. We still have to pay the franchise tax with this structure, and we have no anonymity, meaning you could create an anonymity structure with this Wyoming LLC. The way you create it in Nevada or Wyoming is you use what is referred to as a nominee manager. All right, so when you file this entity, when you set up an LLC, it can be either member managed or manager managed. We set them up as manager managed. So we have a person over here, all right, we'll call him A.T. Mathis. A.T. Mathis is your initial manager of your LLC. So when we file it, we say A.T. Mathis is the manager. So his information is listed with the Secretary of State. But A.T. Mathis, he resigns his position as soon as the entity is filed, and control is turned over to you. But no one knows about it, because in Wyoming and Nevada, we do not have to update the state whenever there's been a change in control like this. And you only have to list the information once a year. If you tried that up here in California, so if we stuck A.T. Mathis up here as your initial manager for filing purposes, and then we changed it back to you, we're obligated by law to let California know whenever there's a change in management. So we'd have to tell them right away, well, A.T. Mathis is no longer there, you're back in that position. So it only works in Nevada, Wyoming, and Delaware, this type of strategy. But the reason why you're not going to have anonymity, okay, if you did this, is because the horse has already left the barn. The genie is out of the bottle, so to speak. That is, we've already filed these entities in California. Your name has already been associated with them because your structure was set up in this manner. You started here, then you went to here. Now, that is not my recommendation when it comes to creating these structures. I like to flip it. I'm going to show you that in just a moment. So if we have this structure in place and you set it up this way, you're not going to have anonymity, and you're going to be subject to the franchise fee and all these California entities. And by the way, in order to obtain the outside protection, this LLC, even though it's in Wyoming, is also going to be subject to the franchise tax, because these 3 returns here will report that these companies are owned by Wyoming LLC. And then you'll have to report this Wyoming LLC to the Franchise Tax Board, because they're going to ask who owns it and who's the manager, and you'll list yourself. And so they'll say this is subject to franchise tax. So this one would then increase this another $800. If you want to minimize the franchise tax on this entity, there's one way to do that. And the way we do that is we bypass you initially, or take that LLC out of the equation. Oh, sorry about that. And what we do is we create what is called a personal property trust, what is called a PPT. And it's just a grantor trust that's set up to hide ownership of personal property. Your ownership interest in an LLC is personal property. So we take these interests now and we assign them over here. And I do this for reporting purposes for the Franchise Tax Board. So they do not see your Wyoming LLC. Now the personal property trust, it doesn't have to file a tax return. It does nothing. It's just a personal property holding entity. That personal property trust is in turn owned by a Wyoming LLC down here, of which you're the owner. Now by setting it up in this manner here, you're able then to take away this drawback right here. You're still left with no anonymity because you originally created these entities with your name on them, but you've got no franchise on the Wyoming entity. Okay, you have to pay franchise here, 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 and you have no anonymity. But we eliminated the $800 on the Wyoming because it's not going to be reported anywhere. By the way, this Wyoming LLC is always going to be a disregarded LLC for tax purposes. So it does not show up on your personal tax return. Everything passes through to you. In fact, all of these LLCs up here, unless they own commercial property, should be disregarded entities flowing through to you. Why the distinction? Again, beyond this webinar, come to the asset protection event. We'll go into that in more detail. For commercial or apartment buildings, why you do not want to use disregarded entities. All right, so this is the owning the real estate portion if you want some privacy. Now, these scenarios thus far assume that you've already created a structure, and what we're coming in to do now is provide you some protection and clean it up, make it stronger than what it is. So you receive more than just the inside liability protection. But let's assume that you came to us and you said, hey, Clint, I've got some assets here and I want to protect them if it's some real estate and maybe you have a brokerage account, some savings account. Well, how do I go about protecting them if we just started with a fresh slate altogether? Well, the way I would do that, let's assume we have these 4 homes again, or 3 homes, excuse me. We need to use a combination of different forms of entities to protect protect these properties overall to obtain the benefits we're looking at. So the first thing we're going to do is we're going to create what is referred to as a land trust over all of these properties. Now, land trust does not offer asset protection. That's why I don't stop with the land trust. We have to go on beyond that. But we start initially with the land trust. A land trust is like a living trust. All right? The difference is that I can assign my ownership in this trust to anybody, any entity that I want to while I'm alive. So if we started out with Clint being the owner of the land trust, and then Tracy, who's my wife, she wants to own it, I could then transfer my interest. I step out of the picture, she becomes the owner of the trust, or what we refer to as the beneficiary. Now she owns it. So that's the benefit of a land trust. Over a living trust, in order to make this type of move, you have to die. And so we're not using living trusts here because in order to get the asset protection, you have to knock yourself off. And we don't want to do that. So we start with the land trust. Now, these do not have to register with the Secretary of State. They're merely a title holding vehicle. Now, in order to attain asset protection, we need to create an entity that gives us the asset protection. And of course, that's going to be our limited liability company. So we'll now create 3 LLCs. 1 LLC per property. All right, so we got 3 LLCs set up. Question you're probably asking yourself is, where is Clint going to create those LLCs? Well, because you're in California, and I know if I created 3 California LLCs here, it would cost me $2,400 a year for the asset protection. Wouldn't it be great if we could eliminate that? So you don't have to pay $2,400 a year. How about if I were to cut it in half to $1,200 a year? Well, then you might be thinking, well, that's only $400 per entity. That's even better. Well, we'll cut that even further. I'll cut it down to $0 per year. Nada, nothing. If you set these up in Wyoming, because Wyoming does not have a franchise tax. So Wyoming is where we're going to create our LLCs, and we're going to have our land trust owned 100% by our Wyoming LLCs. So From an asset protection point of view, if something happens here with a tenant, then the beneficiary of this LLC is the responsible party. Yes, you sue the trust, but you also sue the LLC. So it goes from here to here, and that's where it stops. So we use a land trust to own a Wyoming LLC to own our California land trust. Now these LLCs are taken outside of California. They're not going to be subject to franchise tax. But we're not going to stop there. I'm still going to have you put together a holding LLC here. This is our holding LLC. This is a key component to all structures I create. I always put a holding LLC in place. And this holding LLC will own your various LLCs right here. And again, this is going to be a separate Wyoming LLC. Now, there's a few reasons for this strategy. Okay? Number one reason why I do it is that my clients, you have your cash, your profits from your property. They should reside here. If you have a brokerage account for your stocks and bonds, all right, with, say, Charles Schwab, you need to open it up in the name of this LLC. So now you're gaining protection for your liquid assets, not only your real assets, real property assets. We've now just begun to protect our liquid assets as well by putting them in here, because if we got sued, they couldn't take them from us. Another reason why I'm doing this is that I want these interests here all held here. So if somebody did sue me and they said, well, what do you own? Well, in this structure, if this is me, how many LLCs do I own? You'd be surprised if you're thinking on this right now. If I were to probably poll 50% of the people on this webinar right now, I guarantee it, because I've done this, there will be 50% of you at least that will say, I own 4 limited liability companies. I'll say 1, 2, 3, 4. Some of you will look at this and say, well, actually, he doesn't. He only owns 1 limited liability company. But this one LLC owns 3 LLCs. So what I own is what is important in a lawsuit if I'm being sued. I only own 1 LLC. Now, the reason why this is beneficial is because, remember, with a charging order, if somebody sues me and I try to take money out, and here's my creditor over here that came after me and got this bogus claim against me for a supposed broken leg, then that money needs to go to the creditor until that judgment is paid off. Well, that hampers my ability to conduct business, because if I didn't have this entity right here, then it would attach to this one, and this one. But by putting this holding LLC in place, it only attaches here. So I'm free then to move money, take distributions from here and put it in here, take money from here and put it in here, take money from here and move it down to here. You see how I can do this? Because nothing's ever coming out to me. It can go all day long, back and forth, back and forth. As long as it doesn't come out to me, my creditor cannot touch those funds. So that holding LLC is very important for this type of structure. So if we come back here and we go back to our benefits again with this type of structure, all right, you have inside protection from the land trust and the LLC. You have the outside protection now because you've set up your structure in a charging order state. You have anonymity because the Wyoming LLCs, you're using a nominee manager. So your name is not associated with anything in this structure. No one knows that you own the property. Okay, so you have anonymity and you have no franchise taxes with this type of structure. And in fact, this interest here should be held by your living trust is where this ownership is going to go. So if you looked at your 1040, none of these entities have to file a federal tax return. None of them have to file a state tax return. Your 1040 would report all of that property on your Schedule E. So people would think that you own it individually. When I say people, the IRS, they don't know that you've created this structure. But if it's a creditor, it's not the IRS, if somebody's looking at you, they're going to think that you don't own any real estate because it doesn't show up in your name. So this is the preferred structure. Now, one thing you do have to realize, you can set this up, and we do it all the time for our clients, but you cannot manage this real estate through any of these Wyoming LLCs. There is one thing you must create when you adopt this. You do have to create one entity in California. So we're going to create a California LLC or corporation, because this is the entity that will collect the rents on all of the property. So, when I say no franchise tax, it's kind of it's misleading. You will have to pay the franchise on this entity because it will be a California entity, but it's doing business in California. It's collecting rents on behalf of this property, and this property. So just as if you hired a property manager in Florida to manage your Florida real estate, this entity will act the same way. It deals with the tenants, collects the money, whatever's left at the end of the month, it gives the money back to the respective limited liability company that owns the property. So this is how you create a structure now that is compliant, but at the same time offers you several benefits that you can't obtain when you just create the structure originally inside of California. Now, you might be saying to yourself, well, Clint, what happens if I invest outside of California? This is all great for having in California, but if I want to invest in Indianapolis, if I want to invest in Texas, well, how would it change? Do I still have to use the same structure? Not necessarily. If you wanted to invest in other states, then what you can do is we always like to, again, start with your holding LLC that offers you anonymity. So this is my Wyoming LLC. That's me down here in California. So I start with this Wyoming LLC. Then, if I was going to create an Indy LLC right here, the way I'm going to do it is you always start with this LLC first and provide your anonymity shield by using AT methods. So this is number one. We create this as a manager managed LLC. Now there are distinctions. You have manager managed versus member managed, and this is something, again, we go into in depth most at the event. Most CPAs, attorneys, they get this wrong all the time. They don't understand the importance of the distinction. They make decisions that may be accurate, but many times they're not relevant to the client's needs and what they should be looking to accomplish. And that's just because they don't understand the benefits that can come from one form versus the other when you should be looking at using manager versus member managed. So in this case, I want to make this manager managed because we're going to use a blocker person, AT Mathis, to hide our entity, our involvement. Then when I file the entity in Indiana, over here, I'm going to make this one member managed. Okay, I just changed it on you. I'm going to do this one member managed. Now the reason I do that is because the member is going to be my Wyoming LLC. So when I register this one, number 2, in Indiana, it's going to ask me, who owns this LLC? That's what the state will ask. You must list the members of the LLC when you register it here. I will list my Wyoming LLC as its member. So if anybody looks here, they in turn see this. And when they see this, they see this guy over here, AT Mathis. They do not see you. That's how we create an anonymity shield for your out-of-state investing. Okay, we can't do it this way in California. I mean, we could. We could create a California LLC and do the same thing in California. I've done it many times for business owners who are running an active business in California and they want anonymity. We can do that. We set this one up first. We set this one up here. But the problem is you understand, or you have to appreciate the fact that I can give you the anonymity, but I can't minimize your franchise fee. You will be paying $800 on this entity here, and you'll be paying $800 here. A lot of my clients are comfortable paying that additional $800 to protect their involvement with their business because they just don't want somebody coming after them because they think they have a lot of wealth. So this is another way to create the structure. And in fact, this is a very preferred way of setting it up in this manner. All right, so that's LLCs and how you protect real estate. If you have a brokerage account, again, I would set up, if you're not into real estate and you're going to do private lending, you're going to lend outside of the state, I would create a Wyoming LLC, and in here I would put my savings, I would put my stocks, all my brokerage accounts. You can have as many different accounts as you want inside of this LLC. I would lock it all into there. You could do your private lending out of here. If you wanted to lend against real estate located in Texas, you can loan out of that limited liability company. You can make investments in privately held business interests. So this is maybe a corp that's doing the business. You can own that through this Wyoming LLC. So there's a lot of different things you can do with this particular structure, but the reason we're setting it up is to protect your assets. Now, if you want looking for some tax planning, then we bring on, of course, a C Corp. And if you're not doing business in California with this C Corp, it can be the manager of this LLC here. And again, I would create this one in Wyoming. So looking at your assets, I mean, this is why when, at the events, we always sit down with people who attend the asset protection event and we have a strategy session with them, because everyone's different. I mean, there are similarities between individuals who attend these events, but they have different wrinkles to what they're trying to accomplish. And so it's creating the appropriate structure that, it's not only accurate, but as I've stated, it's also relevant to what your goals are. If you say, Clint, I need to borrow money and I want to look good to lenders, well, I'm going to recommend possibly a different structure than what you've seen here tonight to address that particular need for you. And that's going to run contrary to what you might hear from a CPA, because they look at it just from a tax standpoint, or from an attorney who looks at it purely as from an asset protection standpoint. What we do and what we teach at the event is you need to also bring on the business aspect of what you're doing. You never want to create a structure that's going to hamper your ability to conduct business to make money. So this is how I would structure that type of business. Now, the other issue that comes up with the investing you should think about is, let's say that you have a California Corp. Okay, so here's my California Corp, and you're already doing business in California. It's a California corporation. We've been talking about LLCs, but do you know that the stock in your corporation, if you're down here, the stock in your corporation is not protected? Just like an LLC, it offers zero charging order protections. So in that case, what you should do with California stock is utilize this Wyoming Holding LLC. I oftentimes have my clients put their California stock into that Wyoming LLC, make the Wyoming LLC the owner of the stock of their privately held corporation. So they no longer are the owner. They're still up here as the officer and director of the entity, all right? But they're not owning it. It's owned in the Wyoming LLC. So if they're sued individually, their stock is now, and their company is now protected from their personal creditors. So this Wyoming LLC, again, when I say stocks, many times people think, well, he's just talking about Apple, IBM, publicly traded securities. No, I'm also talking about privately held companies as well. In fact, if it's a S corporation, we can even have an S corporation stock held inside of this LLC, because the LLC is disregarded for tax purposes. So you can protect your S corporation stock, not only if it's a C corp, but also if it's an S corporation. So that's something else that I wanted to throw out there I think is really important. And then the last structure that I want to talk about before we get into some questions here is, what about IRAs? All right. Well, a lot of people accumulate wealth inside of IRAs. And just last week, I was dealing with a client who was faced with a scenario as follows. They set up an IRA right here, and their IRA owns a piece of real estate. Well, they had sold this piece of real estate to this individual over here, and turns out that the property that they bought from another individual, kind of gets complicated here. So this person sold it to their IRA. They did a little bit of work there, and then it was sold to this person over here. They just basically put, some lipstick on it. And this person found out that this property was full of mold. In fact, what this owner had done with the property is gone in and covered up all of the mold, put in new flooring right over the mold, did no remediation, did the same thing on some walls as well. This person who owned it in their IRA had no idea, and they flipped it over here. Now, they're stuck in this situation. This person is suing their IRA, and they're the owner. And they told me, they said, well, Clint, I'm protected because my IRA, I may lose the assets inside of there, but they can't come after me individually. That's not true. When you invest in real estate inside of an IRA, you need to be worried about inside protection. Okay, so if something happens on the inside of the IRA, they can still come after you individually. There is nothing that stops them from doing that. This is not an asset protection trust, as it's often as people often kind of insinuate about the way it works in a lawsuit. Further, if you live in California, you do not have outside protection either. So if you're sued, again, here's that crazy creditor that's coming after you. If this crazy creditor is coming after you and sues you, your IRA is not protected. Well, actually, there's minimal protections in California. California provides that your IRA, be it a Roth or a traditional IRA, is only protected to the extent to keep you alive. What I mean by that is to pay you enough money to live on. Now, what does that mean? Does that mean if you have a annual income need of $300,000 and you have saved up inside of your IRA, you've just been putting money aside for the last 25 years, and now you have this nest egg of $8 million that it's all going to be protected because you need that based upon your lifestyle? Not at all. That doesn't mean it's going to be protected because they're not going to look at, you know, how much you spend. What the law says is what's deemed necessary to support you. So if you had a nice big IRA there, they may say, well, you've saved up $6 million. Congratulations for being a saver. But based upon retirement, we think for necessary support for you is only 1.5. So we're going to give 4.5 to this creditor in satisfaction of your judgment. So you have two different areas here you need to be concerned about if you're in California. One, of course, depends on this is universal. If you're investing in real estate, it's not protected. Two, if you have an IRA that you've set up, and that's where you're accumulating your wealth and you're holding the IRA, if you're sued individually, your IRA has very limited protections because IRA protections fall under state law. So how do we address these issues? Number one, right? Do not own dangerous assets in your IRA, all right? Do not own dangerous assets in your IRA. Let me go back here, erase some of this scribble, and I'll show you what I'm talking about. So that real estate example again, you're going to put, if you want to stick with an IRA right here, you've got cash in it, do not buy real estate with it. Set up an LLC that is 100% owned by your IRA, and then put the money into the LLC and have the LLC go out and buy the house from this guy over here who likes to hide the mold. That way, when you sell that property to this person over here who discovers the mold, they sue the LLC and not your IRA. So just like we've showed you, or I showed you with the other examples of protecting your property, you're going to be doing the same thing here. You're protecting your asset. And this is especially important if you still have cash left inside of your IRA because you didn't put it all into real estate. So you want to use the LLC. Your IRA can own an unlimited number of LLCs. There is no limit to the number of LLCs that you can own or your IRA can own. You can have unlimited LLCs. Now, the other thing you may want to consider if you're looking for IRA protections is do not keep money in an IRA, all right? You're probably thinking, whoa, Clint, you just threw me for a loop. What do you mean don't keep money in an IRA? I've been saving money in an IRA. Now you're telling me pull it out and pay taxes on it? Well, I'm not telling you to do that. I'm just telling you to know, I just want you to know that there are other options that offer greater asset protection for your retirement assets. Options that when utilized allow you to do even more with your money. So that option is what is referred to as a QRP, or as a qualified retirement plan. And so one of the things at Anderson that we focus a lot with people that have retirement accounts is moving them from their wealth out of their IRA and into a QRP. So what we'll do is we'll create a entity. Most of our clients have LLCs, of course, or a corporation set up, and it will in turn sponsor this QRP. So it's a sponsor, and this could be a 401k or a profit sharing plan. It depends on what you want to accomplish. And then we'll have our clients roll their IRA money into the QRP. Now, if you're married and your spouse has an IRA, this money can also roll into the QRP. So you can actually roll, both spouses can put their money into one account. Now you can pool the money into this one QRP. You're in complete control of it. You can invest this money any way you want. You're the trustee. You don't have to work through a third party to make the investments with a QRP. It's all up to you. You can even borrow money, a lot of things you can do. And again, I'm going to cover these in more detail at the asset protection event. But from a California standpoint, what's so important here is that a QRP is covered under ERISA, Employee Retirement Income Security Act. And ERISA governs the asset protection benefits of a qualified retirement plan. So this little scenario up here where we had the house, member, and we sold it and had mold and their IRA's being sued, if that happens in a QRP, you're going to be protected. The other benefit you have with a QRP is that you do not fall under the IRA rules. So now you're under ERISA here. ERISA protects your retirement funds from your creditors. The classic example of the person that we use but isn't the best one is O.J. Simpson. Okay? The Goldmans and the Browns have a multi-million-dollar judgment against him, but they cannot collect on that judgment because O.J.'s assets are held in his NFL pension and a house that he owns in Florida. So those funds are protected from his personal creditors. You can protect your funds from your personal creditors by using a QRP over an IRA. In fact, the Los Angeles Times, I forget when it was, they wrote an article about how IRAs are fair games in lawsuits. I mean, you can go to the LA Times website and you can look it up. I don't remember if, when it was. I think it was pretty recent. But they wrote an article about how having an IRA in California, they're at risk in the event of a lawsuit. So if you're in California and you have an IRA with a lot of substantial assets in it, the only way you can gain protection for that is to move, number one, to a state that protects IRAs, so maybe move to Nevada. Or two, what you should do is take and set up a QRP and roll your funds out of your IRA into the QRP. You cannot roll a Roth, though. Roths cannot be rolled into this. It can only be traditional accounts. So I hope you gained some insight into how to protect yourself. And again, we're going to go into this in more detail. There's a lot of moving parts here, and I didn't cover all the details just because you need to know, I need to have an understanding of the individual's assets. And that's why we have strategy sessions when we meet with clients, prospective clients, and go through this with them to show them how these things should be created so that you create an impenetrable shield around your assets. Because really, I see a lot of people think of it like having a bulletproof vest that you create. All right, so here's my vest that I have here. I guess that's not the best looking vest, but you get the idea. There's your vest, and I see people with vests that look like this. All right, so they have holes in it. Now, granted, you've got some protection, but I can tell you this, is that I don't want to go into a gunfight with that hole because there's an opportunity where somebody could be accurate enough where they get in one of these holes, now I'm injured. You want to create a vest that looks like this, where there are no holes in there that somebody can get through. And the way you do that is creating the structure in the proper format and putting together the pieces in the right manner as well. So many things that come together in this, and again, we go through this in detail at the upcoming asset protection event.